Hello, I am attorney Farrey. I am your divorce, custody, and child support attorney here in Atlanta, Georgia. I want to talk to you about one of the questions that I get most often. Parents often ask me, how old does my child have to be for my child to say where he or she wants to live? Most people think that you have to be a teenager. In Georgia, you do not have to be a teenager to start voicing where you want to live. In Georgia, the age of an election of custody is what we call it, is 11 years old. You heard me right. A child only has to be 11 years old to tell the judge where he or she wants to live and which parent they want to have primary physical custody of them. Specifically, OCGA, which is the code section or the law in Georgia, 19-93, says that in all custody cases in which the child has reached the age of 11 but not 14 years, the judge shall consider the desires and educational needs of the child in determining which parent shall have custody. The judge shall have complete discretion in making this determination, and the child's desires shall not be controlling. What that means is that the judge must consider what the child wants to do as early as age 11. However, the child's desires and what they want to do is not binding on the judge, meaning the judge can override what the child wants to do if the judge does not think it's in that child's best interest. Now, once the child reaches the age of 14, the law says, in all custody cases in which the child has reached the age of 14 years old, the child shall have the right to select the parent with whom he or she desires to live. The child's selection for purposes of custody shall be presumptive unless the parent so selected is determined not to be in the best interest of the child. Now, what that means is once the child reaches age 14, the person that the child says they want to live with is going to be presumed to be the best for the child unless there's some evidence or some sort of proof or indication that the parent the child wants to live with, it won't be in the child's best interest. For example, let's say the child is 14 years old and the child decides that, hey, I want to live with dad, but then the reason and the evidence shows that the reason the child wants to live with dad is because dad's never home. Dad lets the child smoke weed, hang out late with his friends, and dad lets him eat junk food. If that's what the evidence shows in court, then the judge can and still will override the child's election, even if they are 14 years old. So keep that in mind. But if you want to have a custody case where you want to change custody to you and your child is at least 11 years old, go for it. From the age of 11 to 13, the child can start saying where they want to live, but you have to have that reason plus any other reasons. But once the child turns 14 years old, the fact that the child now wants to live with you, that in and of itself can be a reason for you to ask the court to grant you full custody of your child. I hope this is helpful. If you want more helpful tips on custody cases and more helpful information, make sure to watch the rest of the videos that I've uploaded on our channel, The Legal Scoop for Fathers. Like, share, subscribe, and also reply in the comments and tell me your thoughts. Until then, see you in the next video.